Good afternoon, everyone. This is Derek Teeter, a partner in Husch Blackwell's Higher Education Group. We are excited to give today's presentation on our immediate impressions of what the withdrawal of federal guidance on the use of race in admissions by schools means and the steps that you can and should take in the coming months. Before we begin in substance, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program. I'd like to take a minute to highlight just a few of those for you. If you have any questions during the webcast, please submit your question via the question box. We will try to answer all the questions you submit today, but if a fuller answer is needed or we run out of time, we'll try to follow up by email. We appreciate audience participation and encourage you to submit your questions. If you have any technical difficulties, please click on the Help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the Resource List icon that looks like a folder at the bottom of your screen. This program has been approved for Illinois, Missouri, Nebraska, and Tennessee continuing legal education credit. Colorado, Iowa, Indiana, Texas, and Wisconsin credits are pending. To report your hours in Illinois, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. Joining me on today's webinar is my partner, John Borkowski. John is also a member of the education group at Husch Blackwell and represents school districts, colleges, and universities, as well as other nonprofits and businesses in the education sector. And John frequently defends schools in civil rights litigation and advises clients on the use of race-conscious admissions policies. And here are our lovely pictures and contact information if you'd like to follow up with us on anything that we cover today. All right, so let's dive in. And I'll pose this question to John to start us off. So something important happened on July 3rd, John. The federal government withdrew some guidance. So can you sort of walk us through exactly what happened?
Sure, Derek. Thank you. So right before the 4th of July holiday last week, the Department of Justice and Department of Education jointly issued a Dear Colleague letter that announced that they were withdrawing 7 pieces of sub-regulatory guidance, all of which dealt with the use of race by educational institutions. Some of them were directed at the K-12 world. The majority of the guidance documents that were withdrawn spoke specifically to higher education. And these were all 7 guidance documents that were put together during the Obama administration and expressed the prior administration's interpretation of Title IV, Title VI, and the Equal Protection Clause of the Constitution as it relates to considering race expressly for the purpose of promoting the educational benefits of diversity. And all of those guidance documents were withdrawn.
And so you use the term sub-regulatory guidance, and I imagine we have some non-lawyers on the call today, and that may merit some explanation. When we say sub-regulatory guidance, we're talking about informal guidance issued by departments, not a statute, not a regulation that went through notice and comment rulemaking, but rather Dear Colleague letters which telegraph or indicate the department's enforcement position on those underlying laws. And also, in addition, the department reposted a piece of sub-regulatory guidance from the Bush administration, 2008, that, as we'll discuss in a moment, has a slightly different take maybe on where we're at with the use of race in admissions. And as John indicated, the withdrawal of this guidance directly impacts 2 provisions of the Civil Rights Act, Title IV, which is really more of a K-12 specific piece of civil rights legislation, Title VI, which you're all probably more familiar with, and also the Equal Protection Clause of the Constitution, which governs the public institutions that are on the call. So John, can you walk us through the sort of specific guidance that's been withdrawn and what subjects it covered, or what cases, I guess?
Sure, and before I do that, let me say one other thing that I think will lay the groundwork for some of the things that we want to discuss later in this call about subregulatory guidance of this nature. This guidance does not have the force of law. And it doesn't even have the force of a regulation. But what it often does is provide a safe harbor. We often advise clients that you don't necessarily have to do what is called for by Department of Education or Department of Justice guidance document, but if you do it, you can expect the Department of Justice to line up on your side. So let me talk a little bit about these guidances. The first set of them listed here came out on December 2nd, 2011, and they were guidance documents that dealt with the use of race to promote diversity in both post-secondary education and in elementary and secondary education. And they were guidance documents that really were an effort to respond to the Supreme Court's decision several years before, in 2007, in a case that was a K-12 case that I was involved with, involving a couple of school districts in Seattle and Louisville, Kentucky, and whether diversity was a compelling interest in K-12 as well as in higher education, and if so, what type of plan could survive strict scrutiny, the applicable constitutional standard. And that case came out in 2007, and the new administration came in the following year, and it took several years for these guidance documents to be developed, and they were developed through a long and intensive consultation process, both within the agencies themselves. The agencies also worked with higher education leaders, civil rights leaders, K-12 leaders, to really try to tease out the consequences of that, of where the Supreme Court's case law was on the use of race, and that process made these documents a little bit unusual in their scope, because they really tried to put some very practical examples and really advice in them. The second two sets of guide, or the next four of guidance documents, were all sort of elaborations of these that dealt with the Fisher case each time it came out, and then the Schuette case from Michigan, and sort of clarified and amplified the 2011 guidance documents. And Derek, you may want to talk a little bit more about the way those 2011 guidance documents are broken down and the different features they cover.
Yeah, so I mean, the documents are several pages, and we can't obviously go through all the details of them, but it's fair to sort of encapsulate what these guidance documents did at a conceptual level. And first and foremost, they're an attempt to distill down for the reader the operative rules that the Supreme Court set in its various decisions on the use of race, including the cases that John described. And of course, those underlying Supreme Court decisions are definitive interpretations of the statutes and the constitutional provisions at issue. And so when we talk about the guidance being withdrawn, the technical guidance document has been withdrawn, but the underlying Supreme Court decisions that in large part the guidance document took care to describe remain. and are the law and lesson until the Supreme Court changes it. So that was a significant part, probably the largest part of what these documents did. Another thing they did, which was frankly a change between the Bush administration and the Obama administration as it came in, these documents speak quite favorably about the benefits and values of creating a diverse student body, and in some ways might even be interpreted to encourage schools to sort of utilize the space the Supreme Court created for them to use race in a sort of nuanced way in admissions. And so that encouragement, that speaking favorably about the use of race-conscious admissions is throughout these documents and was a change in tone and also thus an indicator of the department's sort of enforcement posture, whether they would look critically or more generously upon a school's race-conscious admissions program. The next thing the guidance did was to walk through some specific steps that an institution would take were it to create a race-conscious admissions program. So what things must one do in order to comply with the Supreme Court precedents? And we'll tease out sort of what the substance of that is in a moment. And then the last thing the guidance did, and in particular the 2011 guidance, was to include several specific examples of particular actions or hypotheticals that a school could take consistent with the Supreme Court guidance on the use of race in admissions. So those are sort of the four conceptual things that the guidance did. And it's interesting to think about the guidance in that way because it starts to line up then with what was the rationale the current administration gave for withdrawing this guidance. And there were really three rationales articulated by the current administration. One was the critique that this guidance advocated specific policies and procedures beyond the requirements of the law, said the withdrawal letter. I think there's a couple of really important points built into that rationale. One is that when we talk about the use of race-conscious admissions and the Supreme Court cases that describe sort of the permissible bounds of that, the case law is speaking to what an institution can do if it wants to. Absent someone having been sued for historic discriminatory practices and being made to remedy those, schools aren't obliged or required to use race. So the current administration is saying that, at least in its view, the guidance was faulty and should be withdrawn because it was encouraging people to do more than what the law required, and the current administration doesn't view that as an appropriate use of sub-regulatory guidance. So that's one of the first rationales. The next one was a critique of the use really of the examples and the hypotheticals that were put into the guidance. The current administration takes the position that it was inappropriate through the use of that guidance to sort of prospectively tell people what would or would not be a particular permissible use of race in admissions. By critiquing the guidance in that way, what the department may be saying now is that it's wanting to reserve its ability in particular cases to come in and take the position that the use of race-conscious admissions programs is not appropriate in a certain case. That isn't to say that all the examples the old guidance gave were wrong and wouldn't pass muster today, but the current administration, it seems, didn't want to be shackled by those examples that had been given in the old guidance. And I think as a general proposition, sort of overlaying both of these two, the current administration has, not just in the case of higher education and race-conscious admissions, but generally taken a view that agency guidance documents should be used sparingly and fairly narrow in their articulation. One can debate whether or not the administration has followed that in its own way, but that was an articulated rationale as well for the withdrawal, simply that the department was overly aggressive in its sort of use of sub-regulatory guidance. So one of the things we're sort of beating around here, I guess, John, and ask you to share your perspectives with our audience, what does this mean for a school's risk going forward, or what does it sort of telegraph, if you will, about where the department's headed?
Sure. It's difficult to say exactly what it portends, but let me give you, because it's only a page-and-a-half letter, but let me give you a few reflections on that. On their first rationale for withdrawing this, which was, basically the administration's objection that, or observation really, that the prior guidance said diversity is a compelling interest, and not only does the Supreme Court found it, but we think it's a compelling interest, and we really think you should pursue diversity. And I think it's not surprising to me that the new administration has a different view on that, and I've always thought this guidance, ever since the presidential election and the comments about the use of guidance, I always thought this particular guidance was at risk. The other part that's a little trickier about the rationale, and that feeds into your question, is this notion that giving examples is not a good thing, and that's not an appropriate thing for the federal government to be doing, and I really disagree with that, and that's why I think we have a little mystery here as to what this portends, because the legal standard here that we'll talk about later is that the programs have to be narrowly tailored to a compelling interest. Well, that's a very general statement, and the Supreme Court in a number of cases has talked a little bit about what that means, and we'll talk about that. But what these examples try to do is tease out for institutions things that the prior administration at least thought would meet that standard. And I think you're absolutely right to say that we don't know for sure now exactly what the current administration's position is on the particular hypotheticals, the particular examples in the prior guidance. The new Dear Colleague letter doesn't come out and say one way or another whether it thinks any of the particular examples were themselves substantively wrong or inaccurate interpretations of Supreme Court precedent. But by withdrawing the guidance, they've sort of removed, I think, to some degree, the safe harbor that institutions had while that guidance was in place. And by that I mean, if you did something that was exactly patterned on the existing federal guidance, you could be pretty confident that the Department of Justice or OCR would back you up on that. You might not necessarily win in court. The guidance could still be wrong, but you could be confident that the federal government would back you up if you were following what they suggested their interpretation of the law is. Now I think when you get to some of these race-conscious practices, the Department of Justice and OCR now have more ability to perhaps shift their enforcement position in some of these cases, and perhaps try to push the needle in litigation or in investigations of complaints towards a way in a way that might narrow what is allowed. And so I think that's the big risk here, is that there's a greater degree of uncertainty now, and there's also more chance, I think, or more freedom for the Department of Justice or the OCR to take a position antagonistic to race-conscious efforts to promote diversity.
And when we talk about that enforcement risk, much like Title IX or Section 504, the various other civil rights laws that the Office for Civil Rights and DOJ enforce, there's both a regulatory means of enforcement, that is, the departments come in and do a review of an institution's particular race-conscious admissions program, often prompted because someone's made a complaint, and or the departments have the ability to involve themselves in actual lawsuits, either ones that they file or that private individuals file and the government wants to make a statement in that. And those of you who sort of follow the legal happenings in this space may know that Harvard is currently the target of a lawsuit by a group of Asian students who are alleging that Harvard's race-conscious admissions program is discriminatory against them, and the government has indicated that it very well may file a brief on the substance of that case in the not-too-distant future. So we may know relatively soon how aggressive the department will be, at least in the litigation phase of that. And it sort of remains to be seen whether the Office for Civil Rights, OCR, Department of Justice, become more aggressive in the regulatory sense too. One thing, John, that you mentioned as well is whether or not this portends a change in where the department is trying to take the law. That is, the sort of underlying cases and decisions. What are your views on that?
Well, I think if you look at the 2008 guidance that you mentioned earlier from the Bush era that was reposted, it involved the Parents Involved case, the K-12 case from 2007 that I mentioned earlier, and the tone in that now reposted 2008 guidance was very much, or the emphasis rather, was very much on all the dangers of considering race. And in that case, one of the arguments that was made, just as it's been made in Fisher in the higher ed context, is that really the educational benefits of diversity should not be a compelling governmental interest. And so I think it's quite possible, particularly now with the change in the Supreme Court, that there may be a push ultimately to change the law in this area. I don't think that's necessarily, I don't think that's impacted directly by this guidance being withdrawn, but I think with Justice Kennedy having retired from the bench, and a new nominee who may perhaps be more conservative on these issues, I think the holdings of the Supreme Court about the compelling interest of diversity in the educational context may be reconsidered, and it's quite possible that if they are reconsidered, the Department of Justice might well advocate that the court abandon its prior precedent.
And just to be clear, Justice Kennedy was part of the 5-member majority of the court that in Fisher 2 and Fisher 1 sort of reaffirmed the underlying validity or ability to use race in admissions, at least within the narrow circumstances those decisions articulated. So with that seat being replaced, that creates the potential, at least, for a different shakeout on the court if there's a future case before it.
He also had the key controlling concurring opinion in upholding race diversity as a compelling interest in the K-12 context in 2007. So he's been the key swing vote on this issue since Justice O'Connor left the bench.
Now, are we likely to see that sort of decision coming out of the Supreme Court in the immediate future, John, or what are the potential sort of timelines before we could get to that point? Do folks need to be concerned that something's going to happen before the start of next academic year, or is this a bit longer down the road?
I think it's quite a bit longer down the road. The Harvard case that you mentioned, for example, is pending in a lower court now. There are disputes going on about standing in that case because the plaintiffs are actually I don't think aren't actually students or would-be students. There's an advocacy group purporting to act on behalf of such students, and so there's a standing dispute, and then they'll get to the merits, and then it would be appealed, and then of course the Supreme Court would have to agree to accept review on appeal. So I think that's not going to happen, I don't think, immediately. I think we're talking years rather than months, and it'll likely be months at least before a new justice is confirmed. So I would be stunned if the court took up that issue this term. So I think it's something, though, that we should all keep in mind as a possibility down the road, and I think it behooves institutions to be thinking about, if we, as part of our institutional mission, think diversity is a compelling interest, including racial and ethnic diversity for the educational benefits that it brings to our campuses, what are the other alternatives if there's a change in the law? I mean, we ought to be doing that analysis anyway, as we'll talk about later, in terms of narrow tailoring. But there's at least a potential that the tool of using race as part of a holistic review of individual applicants, could be removed in a 4 or 5 year time frame.
We've been speaking so far, John, about the effect of this federal guidance and federal Supreme Court decisions that permit the use of race in admissions, subject to certain limitations. But as one of our attendees has noted, through a question, there are some specific states that have enacted laws or executive orders effectively prohibiting institutions within those states from considering race in admissions. Does anything that happened with the withdrawal of the guidance affect these state bans on the use of race in admissions?
I don't think it does. I think the only way that I think that there would be a serious impact. Well, I suppose there's two potential ways. I mean, the federal government likely would not have intervened in a case based solely on the state ban, but there conceivably could be a program in one of these states that the federal government might also see as problematic now under federal law. I think that's a little bit unlikely. Obviously, though, the state laws can change, and there's a different procedure for changing the state laws. And so if the state bans were removed in any of these states, then the impact of this withdrawal of the guidance would be the same in these states as in others. But otherwise, I don't see a big impact. Do you?
No, I don't. I think in a strict sense, the withdrawal of the federal guidance doesn't have any legal effect on the underlying state laws. So if you happen to be in a state that has passed a law prohibiting the use of race in admissions by the state's universities, you're still going to be subject to that prohibition despite what the Department of Education or Justice did. I think you're right, John. I mean, sort of looking at the map of states that have bans on the use of race in admissions, a couple of those are rather blue states, and one might see the current administration's actions perhaps prompting state legislators to go back and revise the laws that they've enacted. But that would fundamentally be a political process that would have to see itself play out. Well, so John, if we've sort of suggested, I think we have stated that the withdrawal of the guidance sort of takes away guidance but doesn't necessarily change the underlying law. Where do we go to find the ground rules? What's our authority at this point, lacking that guidance, to determine what the rules are?
Well, I think the rules really are found in the key Supreme Court cases, going back to the Bakke decision, including the Gratz and Grutter decisions involving Michigan, and the Fisher cases involving Texas, and the parents involved case in the K-12 context. I think those key Supreme Court precedents are all still in effect. It's 40 years of Supreme Court precedent, and I think that's where we should look for answers. And frankly, the guidance documents, although they're withdrawn, I think they are substantively a pretty good analysis of the law from the perspective of answering the question: if I want to have a race-conscious admissions program, how do I make it comply with this case law? I mean, that's what they attempted to do. And, as we said, there may be some greater litigation risk now, even if you do that. And so I think what it sort of behooves us all to do is look back at these policies and programs on a periodic basis, like we should be doing anyway, and make sure that they meet the criteria set forth in these major Supreme Court cases.
So I think that's a good segue into a few slides now, where we want to review with you all what those ground rules are, at least at a certain level of abstraction, and walk through them and answer any questions that you may pose as we're doing it. So one of the terms you've heard John use, and I think myself as well in the presentation, is this term called strict scrutiny, which is courts apply different levels of scrutiny to certain actions. And when the government or a private entity that's governed by a civil rights law like Title VI is going to treat someone adversely because of their race, the Supreme Court has said we're going to subject that to strict scrutiny, which is sort of the most rigorous review that the court will give it. We'll look upon it with a fair amount of skepticism and rigor. And so to be able to survive that strict scrutiny, for the court to say, yes, you can do this, you have to demonstrate both that you have a compelling interest in whatever end it is you're trying to achieve with the use of race, and also that the plan or the procedures that you've implemented to achieve that end are really narrowly tailored, are as precise as they can be, rather than overly broad. And so at a high level, the test coming out of cases like Bakke and Grutter and Fisher is to say that for a school to use race in its admissions, it must demonstrate both a compelling interest in doing so, and also then have a narrowly tailored plan when it uses race as a factor in admissions.
Derek,
yeah, go ahead, John.
Just a quick question. To what extent does this strict scrutiny that we're talking about, to what extent is it a constitutional standard that applies to public institutions, or does it also apply to private institutions? I think that's something that we may want to clarify for some of the non-lawyers.
Yeah, and so I guess the fundamental question here is the guidance that we talked about is interpreting both the standards under the Equal Protection Clause of the 14th Amendment, which applies only to public entities, but also to a federal statute called Title VI of the Civil Rights Act, which applies to every educational institution that takes federal money, which is 99% of all colleges and universities. And that statute prohibits the use of race in an institution's programs or activities in a way that is discriminatory. And so the standard really is the same as between those different bodies of law, and in that case can sort of apply to private institutions as well under the Title VI rubric, if you will. We actually have sort of mapped this out for you in a chart that can help you sort of think through the framework that the court has set in its cases. And I wonder, John, if you can kind of walk us through that decision tree, if you will, and explain how we think about this.
Sure. So as Derek already indicated, the two big components of strict scrutiny are compelling interest and narrow tailoring. And let's start with compelling interest. Compelling interest really has to deal with the purpose of the action that you're going to take. Is there a compelling purpose? And one compelling purpose that the courts have found for remedying or for policies that consider race and make decisions in part on the basis of race is remedying identified past discrimination. The other is are pursuing the educational benefits of diversity, or in the K-12 context, also preventing the harms of racial isolation. But the educational benefits of diversity really goes to what is the purpose of the program. Why is it at your institution that it is important to have a diverse enrollment, and how do you define that consistent with your institutional mission and overall priorities? So that's the compelling interest prong. Narrow tailoring is really the heart of what most of these decisions have been about. Most of the language in the decisions has addressed this question of whether the particular program being challenged is narrowly tailored, is designed carefully to serve the articulated compelling interest. And so it's really a question of if you're considering race or ethnicity in a process, are you doing it only when necessary to really promote and achieve your goals? Are you doing it in a way that's flexible? Are you doing it in a way that doesn't have an undue adverse impact on innocent third parties? And are you periodically reviewing what you're doing to make sure that it's still necessary, that there's not another way to do it, that you can't get the same degree of diversity, you can't get the same educational benefits through some race-neutral method? And so those are sort of the two major inquiries that the courts have gone through in all of these cases, most recently in Fisher 2, where the court, again by 5-4 majority, said that the University of Texas's race-conscious admissions program was in fact narrowly tailored to achieve the compelling interest in educational diversity that the university had articulated.
So I'd suggest we unpack a couple of these concepts and sort of dig down in a practical way too. Starting first with this notion of the educational benefits of diversity, because there's a couple of pretty important points built into this as you and the audience sort of go forth and think about where do we go from here. The court has said that it's not enough to just say we value diversity and therefore we have a compelling interest, or a general appeal to diversity writ large isn't going to be sufficient to satisfy a court if your program is challenged. And it's also not appropriate under the case law to say we're going to set a specific percentage quota and that's the compelling interest that we're trying to seek. Instead, and you see this in the Fisher cases in particular, the court is saying, no, you need to be able to explain in a more particular and concrete way what the specific benefits of diversity are that you're trying to achieve. So one example might be we're wanting to educate students how to dialogue with persons of different backgrounds because we want them to be employable in industries where that's going to be an essential function of their job. And that description of educational benefits then, that's a predicate to being able to successfully defend the use of race-conscious admissions, is to be able to say these are the specific benefits that we're trying to achieve. And you need those in part because you have to periodically evaluate your program to decide whether it's achieving your ends or perhaps at some point you actually achieve those diversity benefits that you've sought, and then at that point may not need to use race anymore. John, anything else to add on this sort of educational benefits component of the thinking?
No, not really. I think you did a good job of unpacking that. I mean, I think one aspect of this is that the educational benefits of diversity may not be the same at every institution. There may be different reasons for pursuing diversity, whether it's employability or getting diverse perspectives or enhancing educational outcomes. And in fact, the level of diversity necessary to achieve those benefits also may be different at different institutions. And so it's really in setting up any kind of program like this or reviewing any kind of existing program to promote diverse classes. Really, the first question is, why exactly do we want to do this?
And is this an area where a court is going to defer to a school's sort of reasoned articulation of what those benefits are, or is the court going to look at those and decide for itself whether it's convinced in the first instance? I mean, how do judges who aren't education administrators, I guess, decide whether or not a school's articulable goals are sufficient?
The majority of the Supreme Court has indicated that courts should defer to such reasoned articulations. It's not a free pass, but there should be some level of deference. The big and so lower courts should defer to reasoned, principled explanations of why this is of great educational benefit.
So, John, I wonder if you could sort of take us through this notion of necessity, which, as you said before, is sort of part of the narrow tailoring piece of our inquiry.
Yeah, necessity is an interesting term here because what an institution needs to do is determine that there are not reasonable race-neutral ways to achieve the level of diversity that is necessary to achieve the educational benefits they seek. That doesn't mean, and so that means you have to look at race-neutral alternatives and consider what their impact might be and do so in a serious manner. That doesn't mean that you have to try, every single possible race-neutral thing and see if you can achieve the goals. It means you have to do a reasoned analysis again. You have to really seriously look at race-neutral alternatives and really, if you don't think they can work, be able to articulate exactly why they won't work to achieve the level of diversity that the institution seeks.
I mean, so what are some of the most common, I guess, race-neutral alternatives that your clients have utilized to try to achieve their diversity goals, successfully or not? What concretely are some examples of what we're talking about?
Sure. One large one is looking at socioeconomic factors, either directly or in terms of what regions or schools a student comes from. That's one example. It's also, though, important to realize that the educational benefits of diversity are not the only institutional goal in the admissions process, and so sometimes it's quite complicated because some schools may want to have top academic classes and also have very diverse classes, and so there's a balancing of priorities that goes on, and so I think the educational benefits of diversity and race-neutral alternatives have to be considered in that whole context, because there are some institutional priorities that may work against diversity to some degree.
And at least from my perspective, so this is one of the factors where, in theory, if you had, as an institution, considered workable race-neutral alternatives, you would have a record of that. You would have sort of done your homework and be able to demonstrate to an outside reviewer all the things that you had tried to achieve the benefits of diversity before you went to the extent of using race as a factor in the admissions process. And so if we're thinking about things a more aggressive Office for Civil Rights or Department of Education might fault you for, I think this could be one of them. If you were an institution who sort of didn't document all the race-neutral alternatives you thought about and you went straight to a race-conscious admissions program and don't have a file, you could see a regulator coming in and saying, well, show us everything you considered before. And if you can't, that potentially could be an issue. And that speaks to the Bush-era guidance that was reposted, where the department was strongly encouraging the use of race-neutral methods as opposed to race-conscious methods. So I think this is a factor where we may see some of that new regulatory scrutiny being brought to bear, at least in my view.
I think that's right, Derek. We also just had a couple people ask a question about whether the withdrawal of this guidance has an impact on the consideration of race in financial aid programs, and I don't recall whether financial aid programs were directly addressed by this, but I think in the withdrawn guidances, I don't recall that they were addressed at length specifically, but given that the same legal standards apply, I think most of this analysis would be similar to financial aid programs. I think it would be highly problematic, particularly with the possible changed enforcement posture of the Department of Education and Department of Justice to have any kind of race-conscious financial aid program that didn't clearly satisfy all aspects of strict scrutiny.
I think a somewhat similar question someone posed was, does the withdrawal of this guidance affect the way that we think about the use of other protected statuses, so whether that's sex or age or disability status in admissions? The guidance that's been withdrawn was specific to the use of race. and the specific decisions the Supreme Court has rendered on that subject. So in a direct sense, no, the withdrawal of the guidance I don't think impacts those other forms of protected status discrimination, except to the extent I think it evidences probably an overall skepticism from the new administration to sort of affirmative action-like programs, whatever the status be. But the guidance we're talking about here is somewhat unique to the use of race because of the cases focusing on that. So another factor I guess we need to sort of unpack a bit, John, is this notion of flexibility as the cases describe it. And this was one of the factors on your chart, that if we're going to use race as a factor in our admissions decision, the Supreme Court cases say that that has to be part of a highly individualized and holistic review of an applicant. Or to sort of speak to the converse, it's not permissible to have an admissions program where race is the defining feature of the admissions decision. It has to be simply a part of a much more broad and individualized review. And that's where the court essentially is trying to draw the distinction of saying it can be a factor, but we don't want people being admitted just because they are of a certain race or a certain ethnicity. So if you have a compliant and defensible admissions program that is using race as a factor, it's going to articulate, in addition to race, a whole bunch of other things that you're looking at for your candidates, and you would, in a bona fide way, that is actually looking at all those things and not simply making your decisions based on the race factor. That would be inflexible and run afoul of the Supreme Court guidance. So that's what we're talking about in terms of flexibility. John, can you walk us through this adverse impact or undue burden piece of the analysis?
Yes. This is really part of this standard that really is not talked about a lot in the case law, but it basically looks at the impact on innocent third parties. And so if another student is denied admission and has no other real opportunity to get in, and they're denied based in an identifiable way on their race, that is considered an undue burden. And so it's really sort of the flip side of what you were talking about a moment ago about individualized consideration. You don't want to have a situation, and the plaintiffs in these cases that have challenged these kinds of programs, the Fisher cases being the most recent. The student ended up going on to another university, Amy Fisher, but she was not admitted to the school that she thought she should be admitted to, and she thought that her qualifications were better than students of a different race who were, and so the argument there is that that's an undue burden. So that it's really just the flip side of the individualized consideration or holistic review point. You have to be able to articulate, no, our class is not the way it is because we needed a particular racial makeup. It is the way it is because of all of these competing institutional priorities and values and the way that this unique individual fits into that profile. If you have that kind of policy, if you're able to make that kind of argument, then you're not going to run afoul of the adverse impact prong of the narrow tailoring analysis.
And then the last component to unpack from our chart and our way of thinking is this requirement that institutions must conduct a periodic review of their race-conscious admissions program. And when we say periodic review, we essentially mean walking through this whole analysis periodically. Are there still the educational goals of diversity that the institution wants to achieve? Is it still the case that there are no race-neutral alternatives that could achieve those goals? Is it still the case that your program is flexible and looks at multi-factors and that race hasn't become the predominant factor? So walking through that periodically, because, and you see this in some of the Supreme Court cases, the overall tenor of the decisions, or perhaps the hope, is that at some point the use of race as a factor in admissions becomes unnecessary, that the vestiges of history are sort of overcome. And so that's why the court is saying you've got to go back and look at this and see whether you've achieved that sort of critical mass of diversity benefits that you were hoping. And once you do, then you lose the underlying legal justification to be using race as a factor in admissions. I wonder, John, how you think this element of the analysis plays into the department's sort of enforcement posture, and whether this is something that's going to be scrutinized by OCR and DOJ.
I think it definitely will be, because and so if any institution that has a program of a race-conscious admissions program that hasn't been revised or at least reviewed recently, should probably review and or revise their policy, because like you were saying earlier about sort of keeping a record of race-neutral alternatives, or why just looking at SES wouldn't quite work, or why it's really necessary to look at to accept students with certain academic marks to succeed in your institution, and to continue practices that might work against diversity. Sort of answering those questions and being able to articulate those questions is going to be very important. And in fact, what we see in a lot of institutions is some of those things change over time. There recently been a number of institutions, for example, who've quit looking at or requiring SAT or ACT scores in the admissions process for a number of reasons. But one potential benefit of that is there is, because of the state of K-12 education in our country, there is a sort of anti-diversity effect to looking at standardized test scores as part of the admissions process. And so, as things change over time, I think it makes sense to look at this. But I think, to go directly to your question, I think this administration will be looking carefully at that. And if you have a program that's sort of been running on autopilot for the last 5 or 10 years, you're potentially vulnerable if a complaint is filed or a lawsuit brought.
So we're sort of nearing the end of our time today. If you do have any final questions, now would be a great time to send them in. But I might try to just summarize a few of the salient points, if I can, and then John can chime in as well. So to the extent that you've seen any media reporting or perhaps misreporting suggesting that the department's actions have somehow blocked your ability to have a race-conscious admissions program, that's not the case. The underlying Supreme Court decisions that approve of the use of a race-conscious admissions program remain the law for now. I think what John and I are saying to you is the withdrawal of the guidance has taken away some of the assurance you had perhaps in the safe harbors that the prior administration had articulated. It telegraphs to all of us in the industry, I think, a heightened risk that the current departments will be more skeptical of race-conscious admissions programs and may use their enforcement authority to review those in a more aggressive way. And also that the department may begin to advocate for an underlying change in the law, but that the effects of that, at least at the Supreme Court level, are going to be a 1.5 to 2 years away at the earliest, and potentially never, depending on how the court actually were to rule. So, I mean, John, what are you hearing just amongst clients and industry? What are people sort of doing or not doing at this point? Are they shutting down race-conscious admissions programs? Are they carrying on the same way they were before? Are they doing something in between?
There have been a number of announcements from different institutions that essentially make the point that while they are disappointed in the withdrawal of the guidance, they are going to continue their race-conscious admissions policies because they are confident that they are narrowly tailored to serve a compelling interest. And a number of groups have said that. A number of institutions have said that. But I do think that behind the scenes, a number of institutions are and will be taking a look at their policies and doing the periodic review, using this as an opportunity to review and update their policies to make sure that they're in line with current precedent. I think I don't think this is happening yet to the degree that it should, but I think depending on how the Supreme Court confirmation process goes, I think other institutions may start doing more long-term planning about the future of their admissions policies.
Okay, well, with that, and thank you, John, for that perspective, I think we're out of time today. Thank you for joining us for the program. That we put this one together on fairly short notice, so it wasn't quite as structured as some of our webinars, and we thank you for hanging in there with us. We hope the information we provided was helpful to you and to your institution. If you haven't already, please click on the survey icon at the bottom of your screen to complete a short survey. Your feedback is very helpful to us in designing our future programs. And as a reminder, the program has been approved for Illinois, Missouri, Nebraska, and Tennessee continuing legal education credit, with Colorado, Iowa, Indiana, Texas, and Wisconsin credits pending. A recording of the webcast will be available tomorrow for watching and sharing, and once it is available, a link to the recording will be emailed to you along with a certificate of attendance. That recording will be available for 2 weeks. Please be sure to join us for our next webinar, which is scheduled for July 17th, regarding Clery Act compliance. This concludes today's webinar. Thank you for attending.